criminal procedure in Nigeria. 2 weeks. Administration of Criminal Justice Act 2015. By Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained, these courts shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of these courts, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. These courts, in the interest of justice, will not close its eyes to see. The court will determine all these issues in its judgment.
Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
The defendant?
My Lord.
Consultant, can you tell your...
My Lord, I will not, please, let me finish. Please. It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, another idea that FAN was here, my Lord, another idea that FAN said, and the one thing we will contradict and provide a piece of evidence. A piece of evidence given to the court. I need to write my final written address
on a count charge which reads thus. Defendant, can you listen to the court? Can you listen to the court? I appeal to you to comport yourself, this temple of justice. Please, I beg you to comport yourself.
Show me where it says you can wait.
Beg you to comport yourself.
Show me where it says you can wait.
You
Show me
in the name. You have the right to appeal after my. Can you excuse me? Let him take out. Take him. Excuse him. Excuse him at. Please. Please.
Show me where it says show me.
Please get the microphone from him, please.
I said, show me. Show me.
Excuse me.
Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial and I have to speak. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
I'm under trial. No, listen to me. Please.
The judge must listen to me. No, wait. Wait. I'm asking a very simple question. No, wait. Please, look, this is Supreme Court. Wait, hold on. This Supreme Court.
You cannot show me. I'm a judge. You can't be a judge. You don't know law. You don't know law. Nonsense. Where is the family to address? Where is it? Which law gave you the right to waive my family to address? Which law gave you the right? You can try this. You can try this. What's this one doing here? What are you 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 doing here? Ask me, what are you doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm going. Don't touch me. I'm warning you. Don't touch me. I'm warning you. Don't touch me. Don't touch me. Don't touch me. I said, don't touch me. Don't. Mad people. You don't know law. Show me where it says you can wear my right for like this. Show me the law. Show me the law. Oh my gosh, show me the law. You don't know law. They are demoting you. You are writing rubbish. Show me the law. One address, affidavit. You say you were doing their job for them. God will punish you. Now and forever. Any judgment, let it be on record. Any judgment given in this court is rubbish. Ask him where is the law. Ask for what show. Where is the law? Where is the law?
It's not court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. Where you have the right to get my right to my bed. Show me. Show me.
Well, I will rise and come back. Can you please take him out? I will come back. I rise. Come back if I becomes about 2.
Show me where it says you can wear my right. Show me the place. Show me. Show me.
death of security
Show me!
who were killed.
Which law says you can try me an unwritten law? Show me, you cannot show me.
Who instigated protesters to kill security agents.
You can't be a judge. You don't know law. You don't know law.
By the defendant.
Nonsense! Where is the final written address?
And even
Where is it?
as far as begging in the name of God to please engage counsel and ombudsman, all of which fell on the deaf ear. At a point, the defendant informed the court that he wanted to call about 28 persons as witnesses, some of whom he claimed are foreigners as witnesses in his case. He applied for witness summons. The court graciously immediately approved the witness summons. However, the defendant abandoned these said witnesses and began claiming that he had gone through the case file and he found that there was no law providing for the offenses he is being charged with, that he could not defend a charge not found on the law. By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put in his defense. The court, in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the path he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself, herself, is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant expressly or by conduct waives same. See Segun Ogunsoya and the state citation supplied. The defendant refused to open his defense, despite the court informing him that it was minded to extend the day if he opened the defense on the 7th of November 2027. The court on the 27th of October 2027 made an order that defendant come on the next day to put in his defense or file his final written address, or any written address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th October 2025, the defendant filed a motion on notice / comprehensive written address on notice on address on non-existence of a cognizable charge and the unconstitutionality of continuing of trial filed 30th of October 2025, and will be deemed to be his final written address. That address is deemed as ordered by this court to be his final written address. The import of treating the written address as a comprehensive written address cannot be overemphasized. The word comprehensive, as used in that written address by the defendant, means, according to the online version of the Oxford Dictionary, is, and I quote, including, dealing with all, nearly all elements or aspects of something, unquote. The defendant in the motion on notice and comprehensive written address prayed for reliefs, including 4. The court to discharge him, which is a typical prayer in final written address in criminal matter. No doubt, the defendant clearly knew what he was doing by opting for final written address in form of motion / comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This will therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgment. Also, the preliminary objection filed on 16th October 2025, is also considered thoroughly in these judgments. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to be, when the charge was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce parts of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Court, take it again. Count 1. Registrar, after it, did you understand count 1 I read to you? Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agabi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section 2712 and 3 of the Administration of Criminal Justice Act 2015, which provide us, 1, the defendant to be tried on a charge or an information shall be A, brought before the court unfettered unless the court sees cause otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B, called upon to plead instantly unless where the person is entitled to service of the information, he objects to the non-service, and where the court finds that he has not been duly served. 3, the court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start de novo. This court will not allow matter to be on its court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999, as amended, provide every person, I quote, every person charged with criminal offense shall be entitled to be given adequate time and facility for the preparation of his defense. See the position of the Supreme Court in respect of this provision as enunciated in Igwe and the state, citation supplied. As part of the package of rights available to a person facing criminal charge, he is entitled to all the facilities and enough to time for purpose of preparing his defense. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat JSC in Okoye and COP, citation supply, where my Lord said, and I quote, the moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself. Once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defense, the court must accede to his request and the prosecution has to comply. The facilities that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defense to the crime for which he is charged. This, no doubt, includes the statement of the witnesses interviewed by the police in the course of their investigation, which might have absolved the accused of any blame or which may assist the accused to support such favorable witness that the prosecution counsel may not want to put forward for to testify, unquote. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following date, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel, who he had earlier disengaged, to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denying adequate facilities to prepare for his defense. He had enough time to prepare. That has been represented by senior advocates such as Kanu Agabi SAN, Onyeshi Impeazu SAN, Emeka Ipabas SAN, Paul Urokoro SAN, Haudu Noge SAN, among others, before they were suddenly disengaged. and the defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no basis in this case. Consequently, this issue is resolved against the defendant. On the issue of extraordinary renditions, there are instances where a person commits offense against a country while residing in another country or flee the country soon after committing the same crime. In such instances, the country against which the offense is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Enobuwa citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal fugitive flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have tried and convicted but escaped custody by fleeing the country and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable persons from a country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreement.
Can a cooking oil reduce cholesterol? Yes, rice bran oil can. It is rich in gamma-oryzanol that reduces cholesterol. Alpha-1 in Asia and Golden Terra, Smart Balance oil in Africa help reduce cholesterol.
Treaties signed in recent decades tend to take a dual criminalities approach, classifying and extraditable offenses that are punishable in both jurisdictions. Other extradition treaties, by contrast, tend to list covered offenses, unquote. Usually, the requesting and surrendering nation have a treaty or agreement which allows for such transfer. Nigeria, for instance, is signatory to regional agreements like the ECOWAS Convention on Extradition and other multilateral schemes, such as the London Scheme for Extradition, which within the Commonwealth. The London Scheme for Extradition within the Commonwealth enables Nigeria to request and surrender fugitives to members nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offense is committed. These extraordinary measures may include adoption. This versus Nnamdi Kanu in SC/CR/133C1/2022, where my noble Lord Agim JSC had, and I quote, generally, abduction or kidnapped or any form of illegal removal of an accused from the territory of a state to another face criminal trial or for a reason is prohibited by law. Extraordinary rendition or any other transfer without due process is unlawful. There is no doubt that the illegality in the process of bringing the respondent to Nigeria for the criminal case brought by the appellant against him in Nigeria, the attendant massive violation of his rights, render his prosecution by the appellant unfair and oppressive. While extraordinary rendition measures may, unquote, while extraordinary rendition measure may seem illegal on the face of it, the way and manner in which the attendance of a defendant is secured does not dictate his trial. In the United States of America, this is known as Kelfibril doctrines. This doctrine developed through the case law, notable cases of Kel versus Illinois, 119, U.S. 436, 342, U.S. 519, 1952, where a messenger forcefully kidnapped the defendant from Peru and brought him back to the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority. Addressing Kel's due process challenge, the Supreme Court of the United States held that, and I quote, such forceful adoption is not sufficient reason why the party should not answer when brought within jurisdiction of the court, which has the right to try him for such an offense, and presents no valid objection to his trial in such case. In Freebreeze v. Collins, 342 U.S. 519, 1952, it was a case where the defendant was tried and convicted in the state of Michigan after being adopted by Michigan authority from Chicago, Illinois. Applying its decision in care, the Supreme Court upheld the conviction of the conviction over challenges based on due process and federal kidnapping law. The essence of Kel's Freebreed doctrine is that even though the act of rendition is illegal, a trial court may assert jurisdiction over the person regardless of the legality of the adoption under international law. In recent times, the Supreme Court relied on Kel's Freebreed doctrines in United States versus Alvarez Machines in 504 U.S. 65, 1992. Alvarez Mission, a Mexican citizen, was adopted and brought to the United States at the direction of the Drug Enforcement Administration. The Supreme Court of the United States held that despite his forceful adoption from Mexico by United States officials, it did not affect the validity of his trial in the United States. As said earlier, the issue of extraordinary rendition is quasi-criminal issue, which must be proved beyond reasonable doubt in accordance with Section 135 of the Evidence Act 2011. The law in Nigeria instructs that even a civil matter, once a criminal element is introduced, it must be proved beyond reasonable doubt. For instance, where an allegation of forgery is introduced in a civil proceeding, the standard of proof is proved beyond reasonable doubt. See the case of Minister of FCT versus Finance Consultancies Services. Every forgery involves an alteration of documents, but not every alteration of documents amount to forgery. Forgery involves alteration with a fraudulent intent. The fact and incident of forgery must be specifically pleaded and proved, even in civil matters, as in this case, beyond reasonable doubt. The appellant in this appeal has made allegation of forgery, but failed to prove safe. In a case of forgery, both the original document and the fake must be produced in court for examination. The appellant failed to produce any document in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubt. See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained which allows the adverse party to cross-examine the defendant on his oral evidence. The defendant only swore to an affidavit. So the fact that the affidavit evidence is best used in civil proceedings, where the standard of proof is on balance of probability. The affidavit filed by the defendant is grossly insufficient to establish if indeed he was extraordinarily rendited or he was illegally brought to Nigeria. The gaps in evidence will therefore mean that no evidence was led regarding the extraordinary rendition. Assuming, without conceding, that there was evidence regarding the extraordinary rendition, the court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal and thus vitiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu in appeal number CA/ABJ/CR/625/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, "The consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offense allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hold to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so hold." Unquote. When this issue came up before the Supreme Court, the Apex Court, in Federal Republic of Nigeria versus Kanu in SC/CR/1361/2022, delivered on the 15th day of December 2023, the Apex Court held per ML Gaba JSA, and I quote, I quote my noble Lord M.L. Gaba JSC. I agree with the learned senior counsel for the appellant that the procedure used in bringing or producing the respondent before the trial court for the trial of the offenses in the counts of the charge in questions in respect of which he was validly arraigned did not affect or even go to the statutory jurisdiction of that court to proceed with that trial. The procedure, mode, manner by which the respondent was produced before the court is in before the trial court is in law extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the
Hey guys, big news! Coke is
cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in question. In the above premises, the lower court wishes, with the respect with the respect due to it, took his eye off the ball when it filed off the statutory jurisdiction vested or conferred on the trial court to subject it to procedural law dealing with the procedure for the arrest, extradition, or rendition of runaway fugitive offender to and from the foreign country. The provision of Extradition Act Cap E25, Law Federation of Nigeria 2004, articles and parts of the UDHR 1964 and pronouncement of foreign courts on them referred to and solely relied on by the lower courts to hold that the procedure used or employed to produce the respondent before the trial court to continue its trial had robbed that court of jurisdiction to adjudicate over or tried the offences in question, did not create, define or punish the said offences, neither did any of them confer or vest the statutory judicial power and authority or jurisdiction to try adjudicate over the offences in respondent, was charged with and validly arraigned for. Rather, they all merely provide or prescribe for the general procedure to be adopted in respect of their respective subject matter that do not include and have nothing to do with creating, defining, or punishing offences, and vesting or confining judicial power and authority or jurisdiction on courts to advocate over or try such offences. Once again, these laws and rules, conventions, etc., do not take away, deprive, or rob the jurisdiction of the trial court to adjudicate over or try the offences the respondent was arraigned for on the basis of procedure used or employed to bring or produce him before the trial court for continuation of his trial. I must emphasize that even this court, as the apex court in Nigeria, cannot, by pronouncement, take away, deprive, or even fetter the jurisdiction or conferred or vested on the court of record by the constitution of or a statute, let alone pronouncement by foreign courts on such foreign international convention, treaties, and agreements, or even if domesticated. In these results, the issue is resolved in favor of the appellant to the effect that the trial court is statutorily vested or conferred with the requisite jurisdiction to adjudicate over and try the offences in the retained count of the charge the respondent was validly arraigned for, and that the procedure used and employed to bring or produce him for the continuation of his trial did not rob or deprive that court of jurisdiction. It was an error in law for the lower court to resort to and hold that the procedural law or entirely different subject matter of arrest, extradition, or rendition of runaway fugitive offenders accused person from foreign country deprived or robbed the trial court of the statutory jurisdiction. My Lord argued in the same case also adds, and I quote, the established case law through the cases is that even though a strict alliance to statutory prescriptions concerning pre-trial criminal processes, the processes for bringing the accused to court for trial is a sine qua non for fair trial. Violation of the fundamental rights of an accused person or other unlawful action by the prosecution at the pre-trial stage gives the accused person the right to action for remedy for violation of his fundamental rights and other civil remedy, and has no effect on the validity of the whole criminal proceedings against him and the jurisdiction of the court to entertain the proceedings and try him, provided the facts alleged against him disclose an offence created by written law and a reasonable basis for suspecting he committed the offence. So the established case law in Nigeria is that violation of fundamental rights of an accused person and any illegality in pre-trial or extraordinary process in relation to an accused person should not affect jurisdiction of the court to try ensuring criminal cases and the validity of such cases. That is the basis for the admission of relevant evidence obtained from illegal searches and seizures or searches that violates the accused person's fundamental right to privacy. In Nigeria, there is hardly any case where the jurisdiction of a court to try a case is declared to be ousted by or validity of the case declared vitiated by the unlawful arrest and detention of an accused person at the pre-trial stage of that case or by any unlawful extrajudicial action of the prosecution after arraignment during the pendency of the proceedings in court. The Court of Appeal has introduced a departure from the established case law on the points in Nigeria. What is not clear is if the departure is limited to cross-border cases or include cases within Nigeria. But the erudite restatement of the House of Laws in Al versus Osprey relied on by courts of appeal are couched in terms that suggest that they apply to all cases. This profound judicial restatement appears to give paramount consideration to preventing executive lawlessness, protection of the fundamental rights of the accused, preservation of the rules of law, promotion of rights for territorial sovereignty of states, enforcement of international law, adherence to due process of criminal law to ensure that prosecution does not benefit from abuse of its power and abuse of court process. But the reality in Nigeria's peculiar situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the accused person or other unlawful action of the prosecution that occur in the process of investigating a criminal complaint against him or in the process of initiating the criminal case arising from such complaints or in process of bringing him to court or in dealing with him while he is standing trial. This is because criminal law enforcement officers routinely engage in unlawful actions and brazen violation of fundamental rights of suspects in the investigation and prosecution of virtually all criminal matters. The effect of the holding of the Supreme Court is that, notwithstanding the legality or otherwise of how the defendant was brought back from Kenya, it does not invalidate his trial. The court will curtail the line set by the Supreme Court as the apex court of the land. His decisions are final, override all other courts, including the Court of Appeal, which defendants has erroneously relied on heavily. Kindly see Section 235 of the Constitution of the Federal Republic of Nigeria, 1999, and the case of Adama Tanker Brokering Services Limited against CBN Citation Supply. The fact in this case is more distinguishable. The fact in this case is more distinguishable even than in Kel Freebury case in U.S. with respect to the effect on the jurisdiction of court to try the defendant as held by the Supreme Court per Gaba JSC. In that case, the defendant was already arraigned before this court, and in this case, the defendant was already arraigned before this court, and the jurisdiction of this court had been activated as far back as 2015. More so, he had been compensated monetarily in suits he filed in Kenya, unlike in Kel Freebury case, where the defendants were not on trial before their rendition. Despite the fact that in Kel Freebury they were not arraigned before the extraordinary rendition, their trial were not invalidated in U.S. The defendant in this case, on being granted bail, was alleged to have John bail by leaving Nigeria, and for 4 years. The trial was granted until he was rearrested in 2021 in Kenya. This action of the defendant makes him a fugitive. In this case, the trial has begun and the charge has been filed and read to the defendant before the alleged extraordinary rendition. He cannot then claim that the trial is vitiated by the extraordinary rendition. The alleged rendition of 2021 will not deactivate the jurisdiction of the court activated since 2015, I hold without hesitation that this is an exception to the effect of extraordinary rendition in international law. Even if the extraordinary rendition was wrongful, the remedy for it is at best monetary damages in civil proceedings. The court is aware that a court in Kenya had ruled on this issue and awarded monetary damages to the defendant. The court in Kenya had awarded monetary damages against the Kenya government for gross violation of defendant's rights, fundamental rights. The defendant cannot benefit from monetary damages awarded to him and seek a further relief of his trial being vitiated, particularly seen in nature of the offences, which borders on terrorism. This is similar to the enforcement of fundamental rights to personal liberty in Nigeria. A successful application for unlawful arrest entitles the applicant to compensation or an apology, but it does not extend to vitiating a criminal trial where the charge has been preferred against him. Consequently, this issue is resolved against the defendant. On issue 3, the defendant has challenged this court, arguing that it is based on repeat law. The general rules regarding a charge is that it must be premised on written law. See Section 36, sub 12 of the Constitution of the Federal Republic of Nigeria, and it provides, and I quote, subject as otherwise provided by this Constitution, a person shall not be convicted of any criminal offense unless that offense is defined, and the penalty, therefore, is prescribed in a written law. And in this subsection, a written law refers to an act of National Assembly or a law of states, any subsidiary legislations, instrument under the provision of the law, unquote. The above means that a person to be tried and convicted, the offense must be in existence and provided for under law, a law in force at the time. See the position of the Court of Appeal in Daniel versus Federal Republic of Nigeria, citation supplied. The law is also settled that the trial and conviction of any person upon the repeat law is a nullity. This was the position of the Court of Appeal in IGP versus Ogundimu, citation also supplied. A law, once repealed, ceases to have any life and must be treated as dead. And the Supreme Court in State versus Egigia has initiated on this, and I quote, the law is settled that a repeat law no more has legal life. Thus, it cannot be cited as if it still exists. If it must be cited at all, it must be cited as a repeat law, which has no life to influence an argument. A repeat law cannot be the basis for any comparison with existing law. It cannot be quoted side by side an existing law, as learned advocates state. Now, the defendant argued that the Terrorism Prevention Act 2013 had been repealed by the Terrorism Prevention Act of 2022. Thus, the trial has become spent. The argument by the defendant is quite interesting. It is interesting because it shows the stark misunderstanding of the law by the defendant, as well as his willful disregard of the facts accumulating in his trial. Firstly, the defendant is charged under the Terrorism Prevention Amendment Act 2013. The extant charge is as to offences allegedly committed by the defendant between 2018 and 2021. As at when the extant charge was filed, the Operational Terrorism Act in Nigeria was the Terrorism Prevention Amendment Act 2013. That act was duly passed by the National Assembly and signed into law by the President, Goodluck Jonathan. It empowered the court to try terrorism-related offences and also outline what constitutes act of terrorism. Under Section 30 of the 2013 amendments, the Act provides thus, and I quote, The Federal High Court, located in any part of Nigeria, regardless of where the offense is committed, shall have jurisdiction to try offenses under this act. Unquote. Section 1(2) of the same law defines terrorism as follows, and I quote, any act deliberately done with malice aforethought which may seriously harm or damage a country or an international organization is intended to intimidate a population, compel a government to act or abstain from acting, destabilize a fundamental political, constitutional, economic, or social structure of a country, unquote. The above provisions were enforced 2 years before the defendant's arrest in 2015, meaning this court had requisite jurisdiction to try him then. His initial trial, therefore, was based on an existing and valid legal foundation as at then. This instance means that at the time he was charged, the Terrorism Prevention Amendment Act 2013 was the extant law of the land. It would have been different if the defendant's offenses were allegedly committed after the Terrorism Prevention Act 2022 have been enacted. The Terrorism Prevention Amendment Act 2022 comes into effect on 12th day of May 2022, which is a later date compared to when the alleged offenses were committed. The Supreme Court in Federal Republic of Nigeria versus Kanu Supra, the present defendant in this case also ruled on that issue and held, and I quote, now, even a casual look at the offenses stated in count 1, 2, 3, 4, 5, and 8 of the charge, pleaded to by the respondent before the trial court, readily shows that they are offenses provided for in 2011 Act, as amended and by the 2013 Act, under which the charge was filed and brought, and the respondent was properly and validly arraigned before the trial court. Put another way, the offenses the respondent was arraigned for before the trial court are offenses known to and specifically provided for under and by the provision of 2011 Act as amended by 2013 Act. The offenses are therefore recognized, cognizable in law, to be legally grounded and backed by the provision of extant and existing law that was / is enforced at the material time and now. On its part, count 15 of the charge is indicated to be contrary to section 47(a) of the Criminal Code Act, cap C45, Laws of the Judgement of Nigeria 2004. There can no reasonable dispute that the Criminal Code is an extant and existing statute or act that was or is enforced in Nigeria, which the court has the duty to take judicial notice in this appeal, pursuant to provision of section 122 of the Evidence Act 2011. In addition, the court is also entitled to take judicial notice of the codification and publication of all the acts or statutes, the subsidiary legislations, enactments or passed by the National Assembly as contained in the laws of the Federation of Nigeria, published by or under the authority of the Federal Ministry of Justice of Nigeria at various times, because we here are concerned with laws of Federation of Nigeria 2004, in which the Criminal Code Act is indicated to be. I have noted and pursued the laws, perused the law and acts codified and published in the laws of Federation 2004 as published. The Criminal Code Act is published in Volume 4, comprising of Chapter C24 to Chapter C48. It is in Chapter C38, which is subsequently indicated as Cap 38. The Criminal Code Act is in Chapter 38 of the Laws of Federation of Nigeria 2004, and it's also called or shown to be Chapter C38 in Volume 4 of the publication. It is apparent, therefore, that the Criminal Code Act is not Cap 45 or Cap C45 in Volume 4 of the Laws of Federation of Nigeria, as indicated in Count 15 of the charge against the respondent. Rather, Criminal Code Act is Chapter 38 or Chapter C38 in the Laws of Federation of Nigeria 2004. However, the same Laws of Federation of Nigeria 2004, Chapter 45 or Cap 40, C45 is the Custom and Excise Management Act. A calm reading of the details of the facts stated as constituting the offense mentioned or named therein will clearly and undoubtedly reveal that it deals with offense punishable under the provision of Section 47(2)(ba) of the Custom and Excise Management Act C45, Laws of Federation of Nigeria 2004, which provide as follows: 47(2) if any person A imports or causes to import any goods or conceal in a container holding goods of different description, he shall be sentenced to imprisonment for 5 years without the option of fine. It follows, in the above circumstances, that the mention of the Criminal Code Act as being Chapter C45 and C45 in Laws of Federation 2004 is a mere mistake in place of correct law. The Custom and Excise Management Act, under which the facts alleged to constitute an offense in Cap 15, is punished or punishable. The offense in Cap 15 is consequently recognizable, and grounded in an extant existing law in Nigeria, in which it was defined and described. It is now on-booked law that a charge preferred or filed for offense under a wrong law will not be rendered invalid or incompetent merely on that ground alone, so long as the offense on the charge are known to defined and punishable punishment provided for in an extant law. In the results, the answer to the answer posed earlier in this affirmative in both two counts, that the Terrorism Prevention Amendment Act 2013, under which the offenses of count 1, 2, 3, 4, 5, and 8 are well as.
The world needs moms, providing tasty, nourishing.
The counts of the charge retained by the trial courts are punishable and punished. The offenses, once more, are recognized, cognizable, and ground instant and existing law in force in Nigeria. Assuming without considering that at the commencement of the Terrorism Prevention Amendment Act, the Terrorism Prevention Amendment 13 was repealed, and such is liable to affect the validity of the defendant's trial. I refer to Section 98 of the Terrorism Prevention Amendment Act 2022, which provides 98.1. The Terrorism Prevention Act number 10, 2011 is repealed. 2. Any regulation, order, requirements, certificates, notice, direction, restrictions, authorizations, consents, applications, ongoing cases in courts, requests or things made, issued, given, or done under the repeat acts shall, if enforced at the commencement of this act, continue to be in force and have effect as sealed, made, issued, given, or done under the corresponding provision of this Act. 98.3 provides any proceedings, prosecutions, sentence, judgments, charge, or course of action pending or existing immediately before the commencement of this Act under any of the repealed acts in respect of any rights, interest, obligation, or liability may be continued and commenced as the case may be, and any determination of any court of law, tribunal, or other authorities or person may be enforced to the same extent that such proceedings, prosecutions, sentence, judgments, charge, course of actions, or determination might have been continued, commenced, or enforced as if the act has not been made, unquote. The import of this provision, particularly section 98.3, is it serves as a saving provision which ensures that the amendment of the Act does not affect the validity of trial begun under the repealed Act. This saving clause or preservation provision is aimed at ensuring that pending proceedings or other of courts are not washed away as a result of the commencement of the amended Act 2022, but to ensure a smooth transition from the repealed Act to the amended Act. The sum total of this is that the enactment of the Terrorism Prevention Amendment Act 2022 does not vitiate the trial of the defendant rightly commenced under the Terrorism Prevention Amendment Act 2013. Consequently, this issue is resolved against the defendant. With respect to the substantive issue, I must start the resolution by outlining the effect of the action of the defendant in failing to put in his defense despite several opportunities afforded him by this court. Generally, in criminal trial, the defendant has the three options available to him. Upon the closure of the prosecution case, he has the option of making a no-case submission to argue that the prosecution has not made out a prima facie case against him to warrant him to enter his defense, or that the evidence led by the prosecution so far had been so discredited under cross-examination that it would be unsafe for the court to convict him. Another option open to a defendant is to put in his defense where he will be opportune to state his side of the story as well as present exculpatory evidence in his favor. The third and the final option is to rest his case on that of the prosecution. The defendant in this case chooses to make no case submission, and this court overruled his no case submission on the 26th day of September 2025 and ordered him to put in his defense. It is his constitutional right to do so. He, however, refused to do so. He rather consented to the withdrawal of his learned senior counsel representing him, despite the court employing him to enter his defense. On several occasions, even begging him, in the name of God, as a minister in the temple of justice, passionate about justice, as an apostle of Jesus Christ, I begged the defendant passionately and severally, but the defendant was obstinate and refused, and the court had no choice than to foreclose him. The effect of this is that the defendant has chosen to rest his case on that of the prosecution. The defendant this morning confirmed this fact by saying that he has put in his defense. The effect of the defendant resting his case on the prosecution is that it is a gamble, a risky option, which may boomerang if the evidence adduced by the prosecution is believed by this court. The Supreme Court in Adamu and State, citations supplied, held, and I quote, "The law is generally settled that an accused person who, at the close of prosecution case, decided to rest his case on that of the prosecution as presented against him is only exposing himself to risk and gamble. The reason being that if the case is such that even if all the prosecution witnesses are believed, yet the offense as charged is still not proved, then the accused may get away with the risk of resting his case on that of the prosecution. By that choice, the accused will have decided not to explain any fact in rebuttal of the allegation made against him. See also the position of the Supreme Court in the case of Ajibade and State citation supply, where the court held, and I quote, "Appellant elected not to give evidence in his defense, but to rest his case on that of the prosecution. The election is within his rights under the law, but the legal effect of the said election is to leave the court of trial free to accept the uncontroverted evidence of the prosecution in proof of the charge, which the court rightly did, in my view," unquote. See also the case of Hakim Ibiseyin versus Olajide, citation supplied. The defendant in this case deliberately refused and failed to call any witness and present evidence through his witnesses in rebuttal of the case of the prosecution. The implication is that he admits the case of the prosecution, and the court is entitled to rely on the uncontroverted evidence led by the prosecution. With respect to count one of the charge, the defendant is facing a charge of committing an act in furtherance of an act of terrorism against the Federal Republic of Nigeria by making a broadcast received and heard in Nigeria with intent to intimidate the population and threaten that people will die and the whole world will stand still, thereby committing an offense punishable under Section 1(2)(b) of the Terrorism Prevention Amendment Act 2013. The subsection provides a person or body corporate who knowingly in or outside Nigeria, directly or indirectly, willfully, b, commit an act preparatory to or in furtherance of an act of terrorism, commits an offense under this act and is liable on the conviction to maximum of death sentence. The ingredients of the offense as drawn from the above are: 1. The defendant must be a person or body corporate. 2. The defendant must have done an act preparatory to or in furtherance of an act of terrorism. 3. The defendant must have done the act preparatory to or in furtherance of terrorism act knowingly or willfully, and same may be directly or indirectly. See the case of Ada versus Federal Republic of Nigeria, citation supplied. Looking at the first ingredient, there is no doubt that the defendant in this case is a person. He is known as Nnamdi Kanu. A man is in 50 who stood trial before this court. Thus, the first ingredient is resolved in favor of the prosecution. For the second ingredient, the prosecution led evidence showing that the action of the defendant in making broadcasts threatening that people will die constitutes a terrorist act. Terrorism or a terrorist act, according to online Oxford Dictionary, is, I quote, the unlawful use of violence, intimidation, especially against citizens in the pursuit of political aim, unquote. It is also important to explain what constitutes terrorist acts. Section 1(2) of the Terrorism Prevention Amendment Act 2013 provides us, and I quote, in this section, act of terrorism means an act which is deliberately done with malice, aforethought, and which A, may seriously harm or damage a country or international organizations. B, is intended or can reasonably be regarded as having been intended.
Kivo Prima, Kivo Prima.
Relations. 3, seriously destabilize or destroy the fundamental political, constitutional, economic, social structure of a country or international organizations. 4, otherwise influence such government or international organization by intimidation or coercion. C, involve or causes, as the case may be, 1, an attack upon a person's life which may cause serious bodily harm or death. 2, kidnapping of a person. 3, destruction to government or public facilities, transport system, and infrastructural facilities, including an information system, a fixed platform located on the continental shelves, a public place, private properties, likely to endanger human lives or result in major economic loss. 4, disposal of an aircraft, ship, or any means of public or goods transport and diversion, or the use of such means of transportation for any of the purposes in paragraph B(4) of this subsection. 5, the causing of fires, explosion, or flood, the effect of which is to endanger human life. 7, interference with or destruction of supply of water, power, or any other fundamental natural resources, the effect of which is to endanger human life. D, an act or omission in or outside Nigeria which constitutes an offense within the scope of counter-terrorism protocol and convention duly ratified by Nigeria. The Supreme Court, by my noble Lord Kekere Ekun, JSC, now the CJN, heard in Abdul Mumuni versus Federal Republic of Nigeria, and I quote, Section 15(2) of the EFCC Act provides, any person who commits or attempts to commit a terrorist act or participates in it facilitates the commission of a terrorist act, commits an offense under this act, is liable on conviction to imprisonment for life. Section 46 of the Act provides, terrorism means any act which is a violation of the criminal code or the penal code and which may endanger the life, physical integrity, freedom of, or cause serious injuries or death to any person, any number or group of persons, causes or may causes damage to public properties, natural resources, environmental or cultural heritage, is calculated or intended to intimidate, put in fear, force, coercion, or induce any government body or institution, the general public, or any section thereof, to do or abstain from doing any act or to adopt or abandon a particular standpoint, or to act according to certain principles, or to disrupt any public service, the delivery of any essential service to the public, or to create a public emergency or create general insurrections in a state. Any promotion, sponsorship of contribution to command, aim, incitement, encouragement, attempt, threat, conspiracy, organization, or procurement of any person with the intent to commit any act referred to in paragraph A, 1, 2, and 3, unquote. It was further added, and I quote, the crucial aspect of offense of terrorism is the creation of intense fear and anxiety, both physical and psychological, in the mind of members of the public, which has the effect of coercing, forcing, intimidating them to do or abstain from doing any act or to adopt or abandon a particular view, policy, or position to act according to certain principles, unquote. See also the case of Berende versus Federal Republic of Nigeria, citation supplied. In my research, I came across a handbook from the United States Institute of Peace titled Teaching Guide on International Terrorism. Definition, causes, and responses, where several definitions of terrorism were given as follows. I quote, the calculated use of violence, the threat of violence to inculcate fears, intended to coerce or to intimidate governments or society in pursuit of goals that are generally political, religious, or ideological. Terrorism constitutes the illegitimate use of force to achieve a political objective when innocent people are targeted. Terrorism is defined here as the current use or threatened use of political motivated and clandestine organized violence by a group which aim is to influence a psychological target in order to make it behave in a way which the group desires. See Judgement. The unlawful use of force or violence against persons or properties to intimidate or coerce governments, the civilian populations, or any segment thereof in furtherance of political or social objective is derived from Federal Bureau of Investigations. What therefore, unquote, what therefore constitutes a terrorist act from all the definition above is an act of violence. Threat of violence intended to cause fear, puts the recipients of such violence or threat in a state of fear. Applying the above definition to the facts of this case, the defendants in several of these broadcasts made several threatening harms to the federal government of Nigeria, the general Nigerian populace, including its own people who claim to fight for, who he claimed he fight for. In an interview with Sahara reporter, in an interview with Sahara TV, contained in Exhibit PWW, the defendant was interviewed by one Rodolphe Okonkwo. He was introduced as the founder and director of Radio Biafra. When the defendant appeared on the screen, his nameplate was Nnamdi Kanu, director Radio Biafra. While speaking on the national conference in Nigeria, which was organized at that time, the defendant mentioned the name of some of the representatives from the Southeast as the conference, and he said, if you go there and negotiate any other thing apart from Biafra, you better not come back because our people will be waiting for you, that very person, unquote. When he was asked about the consequence for this representative, including one Ike Nwanchukwu, the defendant was unequivocal when he said, things have changed, and that because the only language that people in the zoo understand is language of violence and force. After all, that very contraction was put together by Frederick Lugard by force. That is what many people don't understand. Lugard killed many people to put Nigeria together, and the killing of people to disintegrate the zoo shouldn't come to anybody as a surprise. Our promise is very simple. If they fail to give us Biafra, Somalia will look like a paradise compared to what will happen to the zoo. It is a promise. It is a pledge. Also a threat to them. They must understand it, that we have had enough of this nonsense. Unquote. It is not noteworthy that defendants in the said interview kept referring to the southeastern part of Nigeria as Biafra. The defendants made some comments, such as the governor of the southeastern state being the stooge of Hausa Fulani godfathers. He even stated that Rochas Okocha, former governor of Imo, had institutionalized the entire state to satisfy its Hausa Fulani godfather. He said nobody had asked Governor Peter Obi about Izu River and the person dumped in the said river. Further, during the interview, the defendants, while answering a question about whether he will embrace a peace separation or choose a violent path, stated at about 7 minutes 30.
You don't just vibe to anything, and that's okay.
In Exhibit PWW, which is a flash drive containing all its broadcasts, said, and I quote, "If they do not give us Biafra, there will be nothing living in that very zoo called Nigeria. Nothing will survive there, I can assure you," unquote. He also made reference to the Nigeria Civil War when he said, in 1967 to 1970, it's not 2010 to 2015. Then we had scientists, but now we have people who can make things happen even better than what we had in the late 60s. So that should ring a warning that we are not joking. 8 minutes mark in the flash. He said, "I do not believe in peaceful actualization of whatever rubbish is called. I have never seen where you will become free by peaceful means," unquote. The defendant also lent support for violent acts when he said he welcomed what a group known as Biafra Zionist group did when they unleashed violence at the Enugu State Government House. He even said he hoped more people will come out to join his group to overthrow the corrupt and inept persons in administration of the government, stating that Biafra must exist and it is their right to make sure it happens. In the broadcast of 16th May 2021, also contained in Exhibit PWW, the defendants in the beginning of the broadcast stated thus: "My name is Mazi Nnamdi Kanu. I am the leader of indigenous people of Biafra, IPOB, and director of Radio Biafra and Biafra Television.